Good morning. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on oversight hearing with Deputy Attorney General Rod Rosenstein. And I'll begin by recognizing myself for an opening statement. Thank you, Attorney General Rosenstein, for appearing for the first time in front of this committee. There is much to discuss today, and we look forward to your testimony and answers to your questions. As chairman of the committee with primary oversight of the Department of Justice and the FBI, I have always supported the department and the FBI in performing their valuable missions to keep our nation safe and to hold individuals accountable for criminal conduct. Yet, I and many on this committee now find ourselves in the very difficult position of questioning the actions of both prior and current department and FBI leadership. You have a unique role at the Department of Justice in that you appointed Special Counsel Mueller and have a supervisory role over his investigation. It is therefore very appropriate for you to appear before this committee to answer questions related to the scope of the Special Counsel's investigation, as well as its current efficacy in light of various events calling into question its impartiality. Reports on the political predisposition and potential bias of certain career agents and department lawyers on Special Counsel Mueller's team are deeply troubling to all citizens who expect a system of blind and equal justice. The Department of Justice investigations must not be tainted by individuals imposing their own political prejudices. We are now beginning to better understand the magnitude of this insider bias on Mr. Mueller's team. First, we have FBI agent Peter Strzok and FBI lawyer Lisa Page exchanging communications showing extreme bias against President Trump, a fact that would be bad enough if it weren't for the fact that these two individuals were employed as part of the Mueller Dream Team investigating the very person for whom they were showing disdain. And calling it mere disdain is generous. According to the documents produced last night to this committee, Mr. Strzok and Ms. Page referred to the president as an utter idiot, a loathsome human, and awful, while continually praising Hillary Clinton and the Obamas. These text messages prove what we all suspected. High-ranking FBI officials involved in the Clinton investigation were personally invested in the outcome of the election and clearly let their strong political opinions cloud their professional judgment. And this was only an initial disclosure containing heavy redactions. Second, former embattled FBI General Counsel and current Mueller prosecutor Andrew Weissman expressed his awe of a former DOJ official for shunning the president and failing to faithfully execute the law. However, we are the ones now in awe that someone like Mr. Weissman remains on an investigative team that looks more and more partisan. Third, we have learned that a top Mueller prosecutor, Jeannie Rhee, in addition to the other actions that would normally justify recusal, served as an attorney for the Clinton Foundation. Aren't Department of Justice attorneys advised to avoid even the appearance of impropriety? A former Clinton employee is now investigating President Trump. This seems to be the very definition of appearance of impropriety. Fourth, we have just recently learned that another top Department of Justice official, Bruce Orr, has been reassigned because of his wife and his connections with the infamous dossier and the company from whom the opposition research document originated. We hope to hear your assessment of the foregoing conflicts, whether individuals are being held accountable, and whether you still have confidence in the judgment of the special counsel you named and supervise. Regarding the Clinton email scandal, you, along with Attorney General Sessions, have to date declined to appoint a second special counsel to investigate the improprieties that continue to surface related to the handling of the Clinton email investigation and other events surrounding the 2016 election. These are some of the important issues on which we will focus our energy and questions today. We want to understand your participation and the department's involvement in addressing both investigations. Mr. Deputy Attorney General, the Department of Justice's reputation as an impartial arbiter of justice has been called into question. This taint of politicization should concern all Americans who have pride in the fairness of our nation's justice system. While we continue to call on you to appoint a second special counsel, as you are aware, we have also opened our own joint investigation with the House Oversight and Government Reform Committee to review FBI and the Department of Justice's handling of the Clinton email investigation. I want to thank you and Attorney General Sessions for recently committing to provide us relevant documents to enable robust congressional oversight of this matter. I implore you to continue to work with us on these and other important matters facing our nation. One of these matters involves a critical program for our national security, FISA Section 702. This committee passed, on an overwhelming bipartisan basis, the USA Liberty Act, which maintains the integrity of the program while protecting cherished civil liberties. This overwhelming vote occurred despite the department's lobbying efforts against our bill. The USA Liberty Act was characterized as bad for the program, highly problematic, unworkable, and a proposal that would effectively dismantle Section 702. However, the reality is that this committee's legislation struck a balance that promotes national security and civil liberties. I hope to hear from you why the Department of Justice felt it necessary to oppose a bill that would reauthorize 702 and instill confidence in the American people that their privacy and civil liberties are respected by a government whose duty it is to protect them. The Department of Justice must reacquire the trust of the American people. I know there are thousands of Department of Justice employees and line agents in the Department, in the Federal Bureau of Investigation, that are dedicated individuals that are dedicated to upholding the rule of law and protecting the American people. And I hope that we can come to a conclusion about those people who have not met that standard in this hearing today. Thank you, Mr. Deputy Attorney General, for appearing today. I now yield to the gentleman from New York, the ranking member of the committee, Mr. Nadler, for his comments.
Thank you, Mr. Chairman. Before I begin my statement, first, let me wholly endorse the comments of the Chairman with reference to Section 702 and to the legislation that we reported out of this committee. And second, I want to acknowledge a letter the Chairman and I received last night from the Democratic women of this committee. Our colleagues have written to ask that we convene a hearing regarding the serious and credible allegations of sexual harassment and misconduct leveled against President Trump by at least 19 women. Without objection, I ask that this letter be made part of the record.
Without objection, it will be made a part of the record.
And let me be clear, I unequivocally endorse this letter. We should convene this hearing as soon as possible. This is an opportunity for us to lead and to show the country that this kind of behavior is unacceptable at any level of government. Mr. Chairman, let me start by saying welcome to the House Judiciary Committee, Mr. Rosenstein. For the better part of a year, my colleagues and I have implored this committee to conduct real oversight of the Department of Justice. On January 24th, 2017, we wrote to Chairman Goodlatte insisting that the committee hold hearings on President Trump's conflicts of interest at home and abroad. Citing to experts across the political spectrum, we showed that, quote, the administration's attempts to address its ongoing conflicts of interest are so far wholly inadequate, close quote. 6 weeks later, Attorney General Sessions was forced to recuse himself from the Russia investigation, but we have not held a single hearing on the question of conflicts of interest. On March 8th, we wrote again to the chairman, encouraging him to call hearings on, quote, Russia's alleged interference in the U.S. election. Again, no such hearings were ever held. In fact, this committee, which during the Obama administration held half a dozen hearings around Operation Fast and Furious, received testimony from FBI Director Comey 3 times in 13 months, and detailed staff and resources to a Benghazi investigation that cost the public almost $8 million. This committee, from Inauguration Day until 4 weeks ago, was largely silent in terms of oversight. We haven't lifted a finger on election security. Attorney General Sessions told us on November 14th that he has done nothing to secure the next election from threats from at home and abroad. We have not once discussed the president's abuse of the pardon power. While the hurricane bore down on Houston, President Trump sidelined the Office of the Pardon Attorney to pardon a serial human rights abuser who bragged about running a concentration camp in Arizona. And we have not held a single hearing on allegations of obstruction of justice at the White House, not for lack of evidence, but because, in the chairman's words, quote, there is a special counsel in place examining the issue, unquote, and, quote, several other congressional committees are looking into the matter, and the committee, quote, does not have the time to conduct this critical oversight. I ask my colleagues to keep those excuses in mind. Now, with the year coming to a close, with the leadership of the Department of Justice finally before us, what do my Republican colleagues want to discuss? Hillary Clinton's emails. Let me repeat that. With all of these unresolved issues left on our docket, a week before we adjourn for the calendar year, the majority's highest oversight priority is Hillary Clinton's emails and a few related text messages. As we saw in our recent hearings with the Department of Justice and the FBI, my Republican colleagues seem singularly focused on their call for a second special counsel, and failing that, on the need to investigate the investigators themselves, ourselves. The White House has now joined the call by House Republicans for a new special counsel to investigate the FBI. The President's private lawyers have done the same. I understand the instinct to want to change the subject after the Flynn and Manafort indictments, but this request is grossly misguided for a number of reasons. First, it shows a fundamental misunderstanding of how the special counsel regulations work. Some criminal investigations pose a conflict of interest to the Department of Justice. The Russia investigation is such a case because of the Attorney General's ongoing recusal and because department leadership assisted in the removal of Director Comey, among other reasons. In cases like these, the Attorney General may use a special counsel to manage the investigation outside of the ordinary chain of command. But the key here is the criminal investigation. That's what special counsel does. The department cannot simply assign a special counsel to look at things that bother the White House. There has to be enough evidence to have predicated a criminal investigation in the first place. Then and only then, if the facts warrant, can a special counsel be assigned to the case. So far, there has been no credible factual or legal claim that anybody at the Department of Justice violated any law by deciding not to bring charges against Hillary Clinton or by attempting to meet with Fusion GPS. In other words, there is no investigation to which the department could even assign a new special counsel. Second, the list of grievances raised by the majority for review by a new special counsel also seems wildly off the mark. For example, there is nothing unlawful about Director Comey's sitting down to draft an early statement about the Clinton investigation, nor would it have been unethical to outline his conclusions before the investigation was over if the clear weight of the evidence pointed in one direction. Nor is there anything wrong with FBI agents expressing their private political views via private text message, as Peter Strzok and Lisa Page appear to have done in the 375 text messages we received last night. In fact, department regulations expressly permit that sort of private communication. I've reviewed those text messages, and I'm left with two thoughts. First, Peter Strzok did not say anything about Donald Trump that the majority of Americans weren't also thinking at the same time. And second, in a testament to his integrity and situational awareness, when the Office of the Inspector General made Mr. Mueller aware of these exchanges, he immediately removed Mr. Strzok from his team. To the extent that we are now engaged in oversight of political bias at the FBI, this committee should examine evidence of a coordinated effort by some agents involved in the Clinton investigation to change the course of the campaign in favor of President Trump by leaking sensitive information to the public and by threatening to leak additional information about new emails after the investigation was closed. On Monday, Ranking Member Cummings and I sent a letter to the department asking for additional materials related to these leaks, as well as to the claims that these efforts may have been coordinated with former Mayor Rudy Giuliani, former National Security Advisor Michael Flynn, and other senior figures in the Trump campaign. Third, the President's call for an investigation of the investigation is at best wildly dangerous to our democratic institutions. On the one hand, the President's old lock-her-up cheer seems quaint after a couple of guilty pleas by Trump associates. On the other, as former Attorney General Michael Mukasey, no fan of Hillary Clinton, has said, the President's continued threats to prosecute his political opponents is, quote, something we don't do here. If the President were to carry out his threat, quote, again from Attorney General Mukasey, it would be like a banana republic. Finally, and most important, this investigation into the investigation cannot credibly be a priority for this committee at this time. I understand the instinct to want to give cover to the President. I am fearful that the majority's effort to turn the tables on the special counsel will get louder and more frantic as the walls continue to close in around the President. But this committee has a job to do. President Trump has engaged in a persistent and dangerous effort to discredit both the free press and the Department of Justice. These are the agencies and institutions under our jurisdiction. Every minute that our majority wastes uncovering for President Trump is a minute lost on finding a solution for the Dreamers, or curbing a vicious spike in hate crimes, or preventing dangerous individuals from purchasing firearms, or stopping the president from further damaging the constitutional order. I hope my colleagues will use today's hearing as an opportunity to find their way back to the true work of the House Judiciary.
The chair recognizes the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Did the FBI pay Christopher Steele, and was the dossier the basis for securing warrants at the FISA court to spy on Americans associated with the Trump campaign? Really, when you sum it all up, it boils down to those fundamental questions. Did you pay the guy who wrote it? And did you use what he wrote, disproven, discredited dossier paid for by the Clinton campaign? Did you use it to go get warrants to spy on Americans? That's what it comes down to. And you're the guy who can answer those questions. And yesterday I was convinced that the answer to those questions was probably yes. But today I'm even more convinced the answer is yes, based on the text messages we got to read early this morning. Mr. Rosenstein, you know Peter Strzok? You familiar with that name?
Yes, I'm familiar with the name. And
former deputy head of counterintelligence at the FBI? Peter Strzok, that one?
I don't know his precise title, but yes, he had a significant role in.
Peter Strzok ran the Clinton campaign, interviewed Mills, Abedin, and Clinton, changed the exoneration letter from gross negligence to extreme carelessness. Peter Strzok, who ran the Russian investigation, interviewed Mike Flynn. Peter Strzok selected by Mr. Mueller to be on his team. That Peter Strzok, we learned, had all these text messages. We got to read some of them early this morning. Now, as my colleagues have pointed out, some of them are, they're show he didn't like Trump. He and Miss Page are exchanging text messages back and forth, show they don't like the president. But that's nothing new. Everyone on Mueller's team, no one on Mueller's team likes Trump. We already knew that. But I want to focus on one in particular. One in particular. And this is a text message from Mr. Strzok to Miss Page, recalling a conversation and a meeting that took place in Andrew McCabe's office, Deputy Director of the FBI, recalling a meeting earlier. And Mr. Strzok says this: I want to believe the path you threw out for consideration in Andy's office. Then there's a break. Dash, it says that there's no way he gets elected. No way Trump gets elected. He says, I want to believe that. You said that in the meeting in Andrew McCabe's office. I want to believe that. But then he goes, but I'm afraid we can't take that risk. Now, this goes to intent. He says, we can't take the risk. The people of this great country might elect Donald Trump president. We can't take this risk. This is Peter Strzok, head of counterintelligence at the FBI. This is Peter Strzok, who I think had a hand in that dossier that was all dressed up and taken to the FISA court. He's saying we can't take the risk. We have to do something about it. Now, don't forget the timeline here either, Mr. Rosenstein. Peter Strzok, January 10th, he's the guy who changes the exoneration letter from gross negligence, criminal standard, to extreme carelessness. July 2nd, he's the guy who sets in on the Clinton interview. July 5th, 2016, that's when Comey has the press conference and says, we're not going to prosecute. Clinton's okay, we're not going to prosecute. And then August 2016, we have this text message. The same month that the Russian investigation is opened at the FBI, August 2016. And my guess is that's the same month that the application was taken to the FISA court to get the warrants to spy on Americans. Using this dossier that the Clinton campaign paid for, Democrats paid for, fake news, all dressed up, taken to the court. So I got really just a couple basic questions. Because it seems to me if the answer to any of those two questions, if the answer is yes, if you guys paid Christopher Steele at the same time the Democrats in the Clinton campaign were paying, or if you took the dossier, dressed it all up, took it to the FISA court, and used that as the basis to get warrants, and now we have intent in this text message saying that there's another text message. My colleague referenced it earlier, where Mr. Strzok says, I can protect our country at many levels. Says it with all the humility he could muster. I can protect our country at many levels. This guy thought he was Super Agent James Bond at the FBI. This is obvious. I'm afraid we can't take that risk. There's no way we can let the American people make Donald Trump the next president. I got to protect our country. This is unbelievable. And I'm here to tell you, Mr. Rosenstein, I think the public trust in this whole thing is gone. So it seems to me you got two things you can do. You're the guy in charge. You're the guy who picked Mueller. You're the guy who wrote the memo saying why he needed to fire Comey. You're the guy in charge. You could disband the Mueller special prosecutor, and you can do what we've all called for. Appoint a second special counsel to look into this, to look into Peter Strzok, Bruce Orr, everything else we've learned in the last several weeks.
Yes, Congressman, and I can assure you that I consider it very important to make sure the thorough review is done, and our Inspector General is doing a thorough review. That's how we found those text messages as part of that review.
You've given that answer like 15 times. Let me ask you this. Are you concerned? I mean, this is what a lot of Americans are believing right now, and I certainly do, that the Comey FBI and the Obama Justice Department worked with one campaign to go after the other campaign. That's what everything points to. Think about what we've learned in the last several weeks. We first learned they paid for the dossier. Then we learned about Peter Strzok. And last week we learned about Bruce Orr and his wife, Nellie. I mean, this is unbelievable. So what's it going to take to get a second special counsel to answer these questions and find out, was Peter Strzok really up to what I think he was?
I think it's important to understand, Congressman, we have an Inspector General who has 500 employees and a $100 million budget. And this is what he does. He investigates allegations of misconduct involving department employees. That review that he is conducting is what turned up those text messages. It will also involve interviews of those persons and of other witnesses.
And we're looking forward to his report, and we've met with Mr. Horowitz, and we're anxiously awaiting that report. But that doesn't dismiss the fact that the country thinks we need a second special counsel. 20 members of this committee, the Judiciary Committee with primary jurisdiction over the Justice Department, thinks we need a second special counsel. All kinds of senators think we need a special counsel. I mean, what fact pattern do you have to have? What kind of text message do you have to see before you say it's time for a second special counsel?
I want to assure you, Congressman, as I think the Attorney General explained, we take very seriously the concerns of 20 members of this committee or one member of this committee, but we have a responsibility to make an independent determination, and we will.
I thank the chair.
The chair recognizes the gentleman from Texas, Mr. Poe, for 5 minutes.
Thank you, Chairman. Thank you for being here. Just so it's clear, I'm one of the numerous members of the Judiciary Committee that have asked for a second special prosecutor based on what Mr. Jordan earlier said. The Justice Department is responsible for investigating criminal conduct. Would that include criminal conduct by the NSA?
Yes.
Okay. We all learned under the prison that was happening years ago by the NSA that the NSA was doing, in my opinion, unconstitutional surveillance on Americans and their emails by tracking it and hacking in to see those emails. Came to light under Snowden, after Snowden, who I care nothing for, brought that to America's attention. The NSA said, we're not going to do that anymore, which I think is appropriate because I thought it was unconstitutional. And we've heard reports through the media that there has been unmasking of information. What I mean by that is classified information is seized on somebody, and someone else, an American, that their name is caught up in the communication, and if someone leaks who that was, unmask that individual, my understanding is if it's classified information, whoever does that unmasking has committed a felony. Is that correct?
The only distinction I would make, Congressman, is the unmasking typically is something done in the course of the intelligence analysis. The leaking would be a violation.
That's what I'm talking about, the leaking of that information. And as of today, has anybody been indicted under PRISM? Has anybody been indicted under leaking information on unmasking up until today? Has the Justice Department indicted anybody under those two scenarios and events?
We have indicted, prosecuted people for leaking. I'm not certain whether, I don't believe any of them related to unmasking.
So no one's been indicted, to your knowledge, which I want to bring up now the Foreign Intelligence Surveillance Act. that has been discussed by this committee numerous times. It's the law that allows secret courts to issue secret warrants to try to go get terrorists that are operating overseas and get their information. Does the Justice Department present those FISA warrants to a FISA judge?
In situations where a warrant is required, yes, it needs to be obtained from a federal judge.
That's right. But the Justice Department is responsible for that. Is that correct?
That's correct.
Also under FISA, once again, Americans are brought into the scenario because you target a foreign terrorist, and then you go after their emails, and then you find emails of Americans, and those are inadvertently caught in the surveillance of the target. According to the Washington Post recently, 90% of those inadvertent emails are on Americans. And my question to you is, why hasn't the Justice Department, the FBI, the intelligence community presented to Congress and our request that took place years ago, how many of those inadvertent emails, communications, text messages, conversations have been on Americans? We have been asked for the number. Do you know why that has not been brought to our attention? And let me just follow up with this reason. Here's the reason we need it. We're getting ready to maybe reauthorize 702, which I have a lot of problems with. I think it's unconstitutional in many other ways. But beside the point, here we are at a deadline getting ready to reauthorize it, and still the intelligence community refuses to tell us how many Americans' information has been seized. Can you tell us why we haven't gotten that information that we've asked for years?
No, I testified at a hearing with Director Coates, who I think would be a more appropriate person to answer that because he has access to the data and he has explained it. But I would simply point out that you use the term inadvertent. I think the term that we use is incidental. If you're
incidental, I don't mind the problem. The name of the change.
My point is simply if you're investigating a foreign terrorist, knowing with whom that person is communicating may be relevant to your investigation. And so it's not.
That's not my question. My question was, we're getting ready to maybe reauthorize 702. I don't think we ought to reauthorize it until we find out from the intelligence community where there are no indictments that have been issued against the intelligence community based upon the statements that you have made to see whether or not they're violating the law, and they refuse to give this committee the information about how many people have been caught up in that. And it's been stonewalled by the intelligence community saying, well, we just can't do it. Why can't the intelligence community get some geek over at Best Buy and have them come in and answer that question with a few little taps into the big computer system? We just want the number.
The time of the gentleman has expired. The witness may answer the question.
As I explained, Congressman, I've heard Director Coates explain this, and he's better positioned than I.
So we don't know. Still don't know. Thank you, Mr. Chairman.